Welcome to While You Can, Adventures in Life and Legacy Planning.
Hello and welcome to While You Can, Adventures in Life and Legacy Planning with Amy Reagan, a Florida estate and succession planning attorney who helps professionals, property owners, and business leaders build thoughtful legal plans for every stage of life. I'm Kevin Rosenquist, and today we're talking about the documents you need while you're still living, like powers of attorney and healthcare directives, to stay in control no matter what life throws your way. Amy, welcome.
Thank you, Kevin. Happy to be with you.
Yeah, it's good to see you. I'm excited to chat with you. We're talking about planning for more than death. You know, that's just something that not everybody thinks about when they think of estate planning, obviously. And you've shared stories like your former law school classmate who fell ill while training for a marathon that show how life can change in an instant. Why is it so important to plan for incapacity, not just death?
Sure. Unfortunately, we're all mortals, and eventually life catches up with us, either when we're older in life or when we're very young, like my law school classmate who was, just an all around very good person. He married his high school sweetheart. They had just had a baby. He was training for an ultra marathon. He was in tip top shape in his 20s, really smart, really dedicated, and tragedy struck. He ended up with a terminal brain tumor.
Oh,
And unfortunately, after a very valiant battle, he did lose that battle and ultimately passed. But the planning that we're talking about today can help even before death when you're dealing with those very difficult health struggles, like my friend. And where this comes into play is when you're facing that really big challenge in your life and your health, which you hope to recover from, the last thing that you want to be thinking about is, oh, we should make an appointment with a lawyer so I can get these documents squared away, and then trying
hmm
to have an extra distraction from what you should really be focused on, which is your loved ones and your goals in life. So having that done in advance can really help bring just a little bit extra peace of mind and allow you to focus on what's most important.
Yeah, that is a very, it's hard to say good example, but it's a very, very appropriate example given the fact that you said this guy was in top shape. I mean, ultra marathons are no joke. Like it's obviously, he did everything right from a physical standpoint. You just can't predict. You can't predict. You just don't know what's going to happen down the road.
It's true.
Yeah. So let's start with the power of attorney. What is it exactly, and why is it such a critical document for adults really of any age?
Yeah, so in Florida, a power of attorney is effective as soon as you sign it. It doesn't mean that someone, while you have capacity, is taking away or overriding your rights. Think of it as someone that you're granting parallel powers to you.
Ah,
And
parallel
they
powers.
can
Yeah. Okay.
yeah. And they can really do pretty much anything that you would otherwise be doing. There's a handful of exceptions. One of them is they can't vote for you. Another is they can't sign an affidavit or testify as to your personal knowledge about something. So, Kevin saw someone run a red light. That person you're giving power of attorney to can't say that you saw that.
Yeah, I can't speak on your
Um,
behalf for something like that. Yeah.
yeah, but
hmm
they can access bank accounts. And in Florida, it's a very detailed document. And if you want, for example, your agent to be able to make changes to an existing revocable trust or even create a trust on your behalf, you can do that. You just have to, in addition to signing it and having it properly executed, you have to initial right by that specific power in the document.
Okay. And talk, giving someone that kind of a power is no small ask. So definitely got to think about who you're appointing, huh?
Absolutely. You want to make sure that it's someone you trust and someone who's going to help you carry out your goals and wishes. And this in Florida, when we say a durable power of attorney, that word durable means that even when you become incapacitated, and if you've ever known anybody who has become incapacitated, Sure, it can happen in an instant, like a car accident or a stroke, but oftentimes as people age or they deal with an illness, it can be almost a spectrum or a gradual process of losing capacity. And this document stays in effect throughout. The only time it goes away is if it's revoked, or if your agent refuses to take on those powers, or of course, when you pass away, these powers pass with you. And why would you want it? You would want it so if you need somebody to be able to act when you're not feeling your best or you're not able to act, you have the peace of mind of knowing you have an agent selected, you have at least one backup, maybe two backups in case that person is dealing with their own situation at that time.
So let's move on to healthcare surrogate designations and living wills. Can you break down what those mean and how they work in Florida?
Sure. So oftentimes you'll hear about these documents referred to as advanced directives or medical directives. And they're two similar but pretty distinct documents. A living will is a very narrow set of circumstances where you have, let's say, you're in a vegetative state. At least two doctors don't think that there's a reasonable medical probability of you recovering from that condition. And you're essentially not having capacity. You're not able to do the things that you would normally do to take care of yourself and keep yourself alive. And this document is saying, what kind of treatment would you want in that situation? Would you want, to throw every possible resource at it, feeding tubes, ventilators, experimental medical procedures? Or are you someone who's on the other end of the spectrum where you say, no, if it's my time to go, I would like to be kept comfortable, but I don't want feeding tubes and ventilators keeping me artificially alive. And on the other hand, the healthcare surrogate document is broader. This is a document that you can make effective immediately, granting your surrogate those parallel powers to you. As long as you have capacity, there's no overriding of your wishes. And in fact, even a verbal where you are the person giving the surrogate power, if you change your mind and you tell the doctor, no, no, don't listen to them, listen to me. As long as you have capacity, you can revoke and modify that healthcare surrogate power. So, and it's written right into the document that you can verbally revoke it. And what this document is and why would somebody want it to be effective before they've lost capacity. Again, capacity can dwindle over time. There can be good days and bad days. And when you're facing a serious medical diagnosis like cancer and undergoing the treatments that are aggressive, such as chemo, you might have heard people refer to chemo fog or having some sort of tiredness and fatigue and just not feeling up to, communicating with their doctors and then relaying all that information to their loved ones. Having a healthcare surrogate means somebody can attend those doctor's appointments with you. They can talk to your doctors. They can assist you with medical decisions, and they can relay that information the way that you would want them to, that relieves you and allows you to be able to focus on your battle and whatever health challenges you're facing. And then when you have lost capacity, let's say you have no ability to interact with the doctors, you're in a coma, you had a catastrophic accident or a stroke, and someone needs to communicate with the doctors and they know, okay, they can have access to you, your medical information, and your medical team and help get you the care that you need at that time.
Okay. So that all makes sense. It all sounds right. So let's talk about what happens if someone becomes incapacitated but doesn't have any of these documents in place. How does that unfold?
Well, that can be a challenge. I think one example that a lot of folks might remember from almost, I guess, 20 or so years ago was the Terry Schiavo case, where
Absolutely.
she was not able to advocate for herself. She had loved ones that were at odds about what should be done for her. And that's a perfect example of what people would be wanting to avoid and why they would want to have these advanced medical directives in place.
Yeah, you're doing it
Y-
for other people so that they don't have to make these really like no-win decisions. These tough decisions.
Yeah, and really trying to minimize the court involvement. The court system is very busy, judges are busy, they have a full docket. Hiring a lawyer can be not only expensive, but it's a drain on your, again, time is very precious. And in these battles with health issues, it can be very limited. So, do you really want your family having to get a guardianship judge to award them guardianship over you and your property, or would you rather have a power of attorney already in place, healthcare surrogate designated, and then, in a very dire situation, your living will directive as well?
So you help clients create what you call ambulance ready plans. What does that mean in practice?
Yeah, I don't know if it's really a term of art or it's certainly not a legal term. It's really just about practicality. If you think about, okay, an ambulance is on the way, you're having a medical emergency, the last thing you're wanting to think about is who's going to act for me. If
Yeah.
you've taken the time to plan in advance and you have these documents or copies of them in a safe, easily accessible, you know, place, then, or your doctors and loved ones already have a copy of them, it's going to make that whole process much smoother. And it's one last thing to worry about. And yet, it's a very important thing. Who's having ability to have access to you and your healthcare decisions? That's something that you don't want to be deciding on a whim in an emergency. You want to be able to think through that and have those conversations with those individuals before you designate them.
And it seems like there's a common either misconception or just misunderstanding that these kind of documents are just for older adults. Obviously your story of the person you went to law school with illustrates how that's not necessarily the case. How do you help teach people that these documents are not just for older adults or high net worth families?
Yeah, I think that it's hard to think about young people getting sick or young people facing a terminal illness, but it does happen, and car accidents are prevalent. It's unfortunate, but really accidents do happen. I will say in Florida, scooters and electric bikes, those are pretty dangerous and
Right.
they're designated as such in the statute. So it really highlights how, a lot of technology and things that younger individuals are utilizing can lead to situations where they might need to have these plans in place. And then anybody who turns 18, it's not just a given that your parents are going to have a say with your healthcare. So I think a great graduation gift is at a minimum uh, some healthcare designations for those adult children. And we also have healthcare designations and pre-need guardian declarations for minors. So let's say parents going out of the country, they're going to be gone for 2 or 3 weeks. They leave their minor children with a trusted family member. What if there's a broken bone, a dental emergency? Your child's going to see a medical professional they've never met before in an emergency. That person isn't going to have, who you would want to treat them. You have to have that decided and planned in advance. And the best way to do that is with those medical directives, even for minor children.
You mentioned the pre-need guardian designations. Now, is that something for people who are under 18?
Yes, you can
Okay.
do it for both adults as well as minor children. So nobody likes to think about needing a guardian for themselves. Nobody likes to think about their minor children needing a guardian because that means if your minor children need a guardian, that means something catastrophic has happened to you.
Hmm.
So it's not a pleasant thought, but you can get some peace of mind around the what ifs by having a proactive plan. And that's one important part of having that plan.
What are some of the common mistakes you see when people try to sort of DIY these documents or download templates online?
I think one of the biggest risks is if it's something that's not tailored to your jurisdiction. I think I mentioned before that Florida is very protective of folks, and they're very specific in their requirements for powers of attorney and when they take effect. So I think it was before October 2011, you would have what was known as springing powers of attorney. So it would only take effect if you became incapacitated. That's no longer the case. So if you get the wrong document that doesn't have the specific initial parts for the powers that I mentioned, like creating a trust, for example, or gifting options, those are not going to be available if you're dealing with the wrong jurisdiction, potentially causing you to have a document that may be only partially enforceable or maybe not enforceable at all. Another thing that I see is just mishaps with actually signing the documents. So I saw this the other day, and it's really an unfortunate situation where the person, their intent was clear. They filled out the document, they even had it witnessed and notarized, but the notary forgot to put their stamp on it. And the information that would otherwise be on the stamp was not in that document at all. And that document, in my opinion, is no good. Under
Oh,
the
wow.
clear law and statute, it is no good. And that's very unfortunate. So you can avoid those mishaps hiring an attorney in your jurisdiction. And when I say jurisdiction, your state. So a lot of these rules are based on state statutes. So in Florida, you want to hire a Florida attorney who practices in this area and can guide you through helping you decide, okay, what are your goals? Who are those important people to you? And how would you like your goals carried out? And then having that person that you hire actually be part of the signing process so they know that it's done properly. For my clients, I'm present at the signing. I also have a notary that I use regularly, as well as two witnesses who are there. So I know that I have reliable folks to help my clients get these documents signed properly so they're enforceable. You don't want to be in a situation where you have lost capacity and now your documents aren't even worth the paper they're written on.
Yeah, no doubt. I can't believe that a notary forgot to stamp it, and that's a big oops.
Yeah.
Yeah. All right. Well, as we've learned, life is unpredictable, but your legal plan does not have to be. If you're ready to create peace of mind for yourself and your family, visit aereagan.com and schedule a time to speak with Amy. Also, don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Amy, I always love chatting with you. Thanks so much for being here.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.